Welcome to our friends. Happy Friday. Another weekly privacy chat. I think I've got to go back and say this is our 65th or 73rd or something privacy chat. On that note, we are now loading these as a podcast for those of you who, like me, prefer to listen while walking or exercising or the like, and don't need the pesky video and want to catch up later. So we'll post the link to that and follow our privacy chats. Well, I think you know why we're here. I'm joined by Dr. Gabriela Zanfir-Fortuna, the Global Privacy Lead here at FPF. That means everything outside the United States of America, the big world. And the big world is all increasingly covered by data protection law, and significantly so with the advent of this new law in India covering 1 billion plus people, leaving the US as one of the only G20 countries, one of the only democracies. We'll get there, folks who are listening from outside the US. We will get there. Remember, it took 7 years or so to get GDPR done. And I think what is true today, which wasn't true when I started out many years ago, is we're not just talking about data protection law. We're talking about regulating much of the entire national economy. And with the booming world of AI being such a significant potential future part of the economy, we're regulating perhaps what will be a majority of economic activity in the world. So you know what? In complex economic places where there's a lot of complexity and a lot of other legislation already in place, right? One has got to realize that a good portion of the US world is already regulated. Medical data, credit data, banking data, kids data. So new legislation needs to be crafted in a way that works properly. So it gets harder, but we're going to get there. Also joining me is Raktima Roy, one of the global team's interns, but not an intern. She's a seasoned data protection lawyer from India, now just wrapping up an LLM at Georgetown, and a real treasure to have had us with us, helping us dig not only into this law, but helping support the global team. So she's here across the office from me, actually, and welcome, Raktima. All right, let us jump into this new law. Gabriela, let me turn to you to open up. And let's give a little bit, I don't want to spend too much time on background. It's a huge law. We only have a little bit of time. But if you don't understand the motivation sometimes for a law, the driving factors behind it, right? If you didn't understand, that the sponsors of the California law were worried about, ed tech, you'd say, why are they doing these strange things and departing from, GDPR language, departing from, FTC type language? And then you say, they don't want ed tech to get around it. So that's why you have this unusual wording. That's why the definition of personal information is so odd. Households, why are we specifically mentioning households in the California law? Well, because people know that marketing often focuses on households. So critical to understand sometimes the drivers, because there's a lot to yet be interpreted. And when you kind of understand where this came from, it's going to help us understand. So, Gabriela and Raktima, give us a little bit quickly of how we got here in a way that's going to be relevant to some of the interpretations.
Let me just very briefly say at the top that the observers of the global privacy space have been looking at this bill just since about 2017. The local experts have been drafting specific ideas about how a bill should look like from much longer before that. Our small global privacy community, I know for a fact, has learned, about monsoon sessions and budget sessions of the Indian Parliament, and that the dates always vary every year. And we were waiting always with excitement. Let's see, will it be introduced this time around in the monsoon session or in the budget session? So it's really momentous to see that the most populous country in the world right now, India, is on the cusp, very, very close to have this law. Procedurally, it was passed by Parliament this week, and then it just needs the assent of the president. It needs to be published in the official gazette to become law. I will stop here because I know Raktima has a much, much better short context to give on the impetus that happened in 2017 for the parliament to actually consider a bill on data protection.
Right. Thank you, Gabriela. As you mentioned, this has been in the making for, many, many years. And yes, it has been the defining theme of my entire professional life now for 6 to 7 years as well, the different versions of this bill. So 2017 was actually a big landmark. So the Puttaswamy judgment, the Supreme Court of India in this 9-judge Supreme Court judgment recognized the right to privacy. They read the right to life in the Indian Constitution to include the right to privacy. And they specifically mentioned the right to informational privacy as an element of it. So this was around the time when an expert body led by Justice Sri Krishna was considering setting up a comprehensive data protection framework. And the court observed that this is the need of the hour. In order to actually give effect to this constitutional right, you need a statutory scheme that protects personal data. So from that year onwards, we have had quite a few expert committee reports. We have had a few variations of this law. The first draft, so the expert committee report in 2017 provided the underlying logic of a data protection law through a very, very detailed report, connecting it to India's goals as a digital economy, AI hub, etc. And then in the years following that, we have had a version in 2018, 2019, every year essentially. And 2 of those have also gone to Parliament. In 2019, the version that went to Parliament got referred to a parliamentary committee called the Joint Parliamentary Committee, JPC for short. And in 2022, another version went to Parliament that got withdrawn. So yeah, we have all been watching it with a lot of excitement, and it is genuinely a historical moment for us that now it has passed both chambers of Parliament, and once it receives presidential assent, it will actually become law.
And that's expected, right? At this point, there's
yes, the presidential assent is it's a formality, sort of, yeah. Okay. But again, the government retains the power to notify the law when it wants to. So it could be, September 2023 or September 2025. That is entirely up to the government. And different sections of the law can be notified at different dates. That often happens with big changes in law. So the Companies Act in India underwent this big change in 2013, and then different parts of the law got notified in phases over the next few years.
So when you say notified, that's setting the effective date, not just sort of publishing it. They have
yes, setting the effective date and saying that this provision will come into effect now, and some other provision will come into effect later.
Is there any understanding of how long there will be to get it? Obviously, there's going to be work to get into compliance. So does anyone have any idea? Are we talking a year? Are we talking immediate? 2 years?
That is difficult to say. I mean, definitely the data protection board that will be set up, that's an entirely new body that will need to be set up. So definitely it will take some time. And the other thing that Gabriela and I have been observing about this law is that almost everything has been left to delegated legislation. So actual compliances will have to be notified by rules by the central government before a company that's operating in India really knows what they have to do to comply with the law. So we are definitely looking at a time frame, definitely a few months, if not more. Gabriela, I would welcome your thoughts on that as well.
Let's jump into some of the details. So one of the big issues that people were debating was localization, because there were earlier versions of the bill that did seem to have this whole data sovereignty, keep the data in India, and this created a lot of debate given India's role as a lead outsourcing hub and these sorts of things. So how did they end up dealing with the international data flows and outsourcing compared to, say, compared to Europe?
Well, we've seen a complete turn, and let me start, and perhaps Raktima wants to add some details, but we have seen a complete turn from the original bid scoped out data localization obligations. They were particularly targeting sensitive data, and there was a lot of debate on how broad the mandate will be or how narrow. Then in another iteration of the bill, we've seen the idea of notifying countries where you can send personal data. So quite similar to our adequacy regime that the global privacy space is so familiar with, started by the GDPR. However, right now, in the adopted version, we've seen a completely different approach, which is actually a notification about countries where you cannot send data. So in principle, it seems up until we'll see the government maybe issuing more regulations around it, more guidance. But up until then, we presume that data can flow in other jurisdictions unless a specific country has been notified and blacklisted not to send data there. So that's quite different than a lot of the approaches we are seeing around the world in relation.
Although, Gabriela, probably not that different than what the U.S. over time is likely to do.
True.
We already have a scheme where, highly confidential data, nuclear or things that could be used for, foreign adversarial intelligence, can't go to certain blacklisted countries, shall we say. And I imagine, we don't see today restrictions in international transfers in U.S. law, but I can imagine, given some of the concerns with some of the dangerous countries around the world, there being concern for certain sensitive data going to some jurisdictions. So
that's true.
That's there in the Indian law, though. Just adding that context that localization has been the most controversial thing, I would say, in this law from 2017. Earlier, the idea was that we want India to grow as a data hub, as an artificial intelligence hub, and the Shri Krishna Committee report actually identified localization as a way of doing that. It's a good thing that we have moved away from that now. Having said that, the law does clarify that the existing data localization mandates that are already there in place, this law will not affect that. So we do have sectoral data localization mandates. For instance, payment data, in any transaction in India, end-to-end transaction data, you cannot send it. There are very limited situations in which you can send it out of India. So payment data, telecom data. So all of those sort of sectoral data that is regulated by different regulators, they are free to impose their own restrictions on that kind of data, and the ones that are already in place will remain in place. This law does not change that.
And then there's also this unusual structure for outsourcing data. How has that been handled? Obviously, India, a major hub for call centers, for remote engineering work, huge vendors who support much of the world with software engineering and so forth. How is foreign data that is in India handled?
Well, if you read all of the list of exceptions, and this is one characteristic of this law, you will not see everything that's scoped out of it in the main clause where it defines where it applies and to whom it applies. But if you read carefully throughout the sections, you will see some very targeted exceptions. And one of them is indeed a situation of companies that are based in India and are processing personal data of foreigners, so people outside of India, pursuant to a contract with an entity outside of India. So this type of language technically defines the situation of outsourcing companies, and I'm sure this was a very highly negotiated carve out. Important to say, though, that the exceptions don't cover the entire law. So technically, it does cover I would say the core rights and even the international data transfers rule is exempted for this type of entities. But there are a couple of obligations that they still need to put in place, primarily related to confidentiality and security, like ensuring secure and protection against data breaches type of obligations. But yeah, that's there in the law.
Yeah, and that's been one of the confusing parts of GDPR, where exactly when a service provider, perhaps in Morocco, who is using a service provider in Germany, exactly, and it's pretty complex to sort of understand which obligations of the GDPR do or don't apply, and it's been in a kind of a little bit of a troubling kind of area of confusing interpretation. The security parts apply, but of course, then you've got to make sure you're sticking very carefully within the processor guidelines, or then other rules would apply, and so it can be a bit complex.
Yeah,
let's
kind of similar here as well. Like there's an applicability clause that's separate, so you first have to look into it really depends very largely on the corporate structure where the data processing is happening as well. Because first you have to go through the applicability clause, and then you read that with the exemption clause to see exactly who is exempted, under what circumstances they're exempted. So this is one of those things which it's hard to just say that in general, if you're outsourcing in India, you don't have to worry about it at all. There are circumstances where you might need to worry about it, especially if you have a lot of employees here and they're employed with, say, an Indian subsidiaries, etc. Those are situations where you still have to be concerned. But yes, there is an intent, as Gabriela said, of exempting the BPO industry from the bulk of the compliances, since it is India's bread and butter at the end of the day.
Okay. So let's step up high level for a second. U.S. law, you don't typically need a legal basis when it's not regulated by the other sector-specific laws. You have to worry about deception and unfairness, unless there's sensitive data, in which case maybe there's a consent basis in some states. Okay. Do we need a legal basis to collect and use data under this law?
Yes, you do need a legal basis. There are broadly two broad legal basis. One is consent, and its consent comes with many conditions very similar to GDPR that Gabriela can elaborate on. And then you have this other ground, which is called legitimate uses. It's not very similar to legitimate interests under GDPR, which can be confusing for global practitioners. It highlights very specific situations where you can process data without consent. So for example, employment, medical emergencies. If someone voluntarily provides data and does not say that I'm not consenting to this being used for other purposes. So these are some different specific situations which have been put under the legitimate uses clause. So yes, in order to process data, you do have to either find a legal basis under consent or under one of the legitimate uses.
Okay, and then my second question, once I've found a legal basis, the second question for practitioners often is, okay, how broadly can I use the data beyond the very specific things that I said in a consent, or that were perhaps part of the legitimate use? Is it, necessity? Is it purpose limited? Is it sort of reasonable? So product improvement, marketing uses, machine learning. Give us any information on this.
It's let me just start off, and I'm very happy to let Raktima go into the drill down into the details. But I would say, unfortunately, from my point of view, we don't have a lot of these normal purposes for daily data uses, data processing that are allowed under legitimate uses. Most of that list in Section 7 with legitimate uses actually gives purposes about emergency situations, health emergencies, natural disasters, a lot of competencies and powers to the state to process data for specific purposes. When it comes to private entities, the option is extremely limited. So technically, you have employment purposes So you can process the personal data of your own employees, right? And then you have this voluntary use, voluntary sharing, voluntary providing your own personal data as part of a commercial transaction, for example. But it's the illustration we have there in the text, as Raktima pointed out in one of our conversations, is actually very narrowly defined. As in, yes, you voluntarily provide your personal data when you buy your medicine at the pharmacy, but this exemption, this lawful ground covers the fact that you want to receive the receipt on your phone. So then you share proactively your phone number, and then you receive the receipt on the basis of this. So to just wrap everyone's head around this, companies have very limited options to use these lawful grounds. Looking to the future, I think that this particular voluntary sharing will be perhaps stretched for an interpretation that covers the type of contractual necessity we're familiar with, maybe some of the legitimate interests basis as well in a narrow way. That's my thinking right now. But looking at the actual wording, that's going to be a tough nut to crack. I don't know, Raktima, how you're reading.
No, entirely. These grounds are, I mean, the non-consent grounds are very, very narrow, very, very limited. And Jules, to your original question of improvement of products and other typical uses, it will be quite difficult, I think, to justify that under legitimate uses. And that also brings us to the question of as far as consent is concerned, consent is only valid if you are obtaining consent specifically for a particular purpose, and you're not making consent contingent on agreeing to share data for something that's not actually necessary for that particular service. So given that, unless you can somehow prove that all of the data that you need for different purposes is actually necessary to providing the service, it will be very difficult for companies to use that data for really anything after that.
This is a topic we're going to need to dig into further, because it's really, I don't see how anyone can implement without sort of some understanding of whether product improvement, whether direct marketing, whether sale, whether...
Yes. It's still part of the drilling down, but we love geeking out about these things in our office. There is another one of those carve-outs that is peppered in, which actually carves out processing of personal data for research and statistical purposes. So then it will matter a lot on how research will be defined. Can you bundle in product improvement into that? We don't know yet, but indeed, some of these concepts will need to be further interpreted.
So let's flag a couple of key things. One of the hot issues globally is AI training on personal data, particularly public data sets, data collected on the internet. And it seems that they have addressed this in a way that seeks to allow machine learning to learn from personal data. You flagged the processing for research or statistical purposes, but not if it's related to making a decision about the individual. An independent data protection board. But did I see also that there's like an appeal process, but it goes to like a telecom authority, which is a little bit different than expected. What is this business of consent managers? There's something already in place. You mentioned to me in the health sector, but what is this consent manager? And then significant data fiduciaries have additional obligations of a DPO and DPAs and other audits. So those are, I think, some key things we should touch on.
So I will love to hear more about consent managers from Raktima. This has been something that we've been thinking about for some time, also with our senior fellow Malvika Ragavan, who has been giving us background and context about some of this infrastructure of intermediaries, data intermediaries that is set up or being set up in the past years. But yes, on all of the points that you mentioned, all of these are very important. On the independence of the board, I would say that a very unusual structure around it is that the government, the central government, by invitation from the board or notification from the board, let's say in specific situations, actually has the power to request information, just information, by which we could understand, in my view, also personal data, perhaps. So they have the power to request information from fiduciaries, controllers, but also from the board itself, and from intermediaries as well, that are involved in a particular case that's been investigated by the board. Then also the central government can impose orders that forbid access of the public to specific data, which is a type of provision we usually see in online intermediaries type of bills and responsibility of online intermediaries, right? Like the DSA, for example, and takedown of unlawful content. But this time we see this in the bill. So there is an interesting dynamic there to understand on the powers of the board, the powers of the central government, and then also what's the actual judicial remedy and legal remedy. As you pointed out, there is an appellate court where people that have a complaint or companies can go to challenge the decisions of the board. But it's a very specific designated tribunal, Raktima. Do we understand correctly?
Like an appellate tribunal. Just so essentially the way the law is set out is that when you have a problem as a data principal, you go to the grievance redressal system of the data fiduciary, and if that doesn't work, you go to the board, and then you can appeal from the board's decision to the specialized appellate tribunal that currently also sees appeals from the telecom regulator. And so the board is actually mostly a quasi-judicial authority. I just want to point out that it's very unusual that it's a regulator that does not actually have the power to issue regulations, which is, one would argue, one of the most key functions that a regulator typically has. It's mostly part of this like adjudicating mechanism that is set up under the law. In terms of actual subordinate legislation, delegated legislation, whatever, it's all left to the central government to be notified through rules and notifications, etc. Yeah, which is quite unusual.
The bill prohibits tracking, behavioral monitoring, or targeted ads directed at children, which goes up to 18, right? Yes. Verifiable consent before collecting data from child, teen, or a person with disabilities, but only for the fiduciaries. They have to get verified consent. Is that proper?
Yeah, that's our understanding. And the fiduciaries, they're technically the controllers under the GDPR. So all of the companies that would be a controller, however, the term is changed in this bill. Also, as a flag for people reading about this, the data subject is a data principal. So that's the term for it. And
the data subject, there's some odd things here where the data subject has some penalties in some cases.
Yes, that's one of the oddities. It's not unique though. Our colleague Josh Lee from Singapore has, in our common brainstorm, he was saying, well, Vietnam has something similar as well in their recent decree. However, the obligations differ a bit, I would say, in the obligations for data subjects, in the sense that the ones in the India bill seem a bit more cumbersome. Plus, they come with the potential of a fine. So data subjects can be fined up until 10,000 rupees, which is about $120.
Why? What? How can they be fined? What do they do wrong? Make vexatious requests for their personal information?
Frivolous complaints and stuff like that. Yeah,
that's a real damper on,
entirely,
on, even if you feel that you have a legitimate thing. If you're not a lawyer and you don't understand, and someone tells you, hey, if you exercise your rights, you could have a penalty, that could scare many people who are not sophisticated about or don't want to have a lawyer advising them whether they're legitimate in exercising such a right. So that's a little bit concerning, and perhaps one of the reasons why some in civil society, among other issues, the big carve-outs for government and so forth, are unhappy with this. Well, there's a huge amount to get in here. We are going to be doing some deeper dives into it in some of our member meetings. Got to be some value to being a member and a supporter, right? Got to pay our staff. So we'll be diving down this week into even further detail. We posted links to sort of our high-level summary, which I think is helpful and useful, and we'll probably be adding more to this as it plays out. Training. Our training team would like you to remember that we've got a good collection of training classes in September. We're giving you a break in August. Number of AI-related courses, the EU AI Act, basics of machine learning in a way that most data protection experts, I think, should be able to get a little bit deeper and more comfortable. Take a look at fpf.org for that. I think Raktima Roy, rockstar developing expert in US and global data protection. So keep an eye on her future here. And thank you, Gabriela, for the amazing work you and the global team do. We'll see you next Friday. Actually, next Friday, I think it's next Friday, where I'm going to be joined by an old friend, an amazing reporter, Kashmir Hill. Well, maybe it's in 2 weeks. Well, we'll post it.
Next Friday, Jules. I think it's next Friday.
Is it next Friday? Ah,
yes.
Great. Okay, I'm waiting for my advanced copy of the book. Kashmir has been covering a range of issues for the New York Times, but has really written some incredible stories about facial recognition, and I know her book is going to include a lot of the behind-the-scenes activity. So do join me for a chat with Kashmir Hill about her upcoming book about Your Face Belonged to Us. Have a great weekend, everybody. Thanks for joining us. Happy Friday.